Marilyn K. Edge. In September 2013, Marilyn K. Edge, a 42-year-old financial analyst with a business degree, committed a chilling and premeditated crime that shocked the Santa Ana, California community. Edge, who had been engaged in a bitter and highly contentious custody battle with her ex-husband, Mark Edge, took the lives of their two children, 13-year-old Jalen and 10-year-old Faith, at the Hampton Inn and Suites. The method of murder was poison, though the specific substance used remains withheld by authorities, adding an unsettling element of mystery to the case. The tragic deaths of Jalen and Faith were not random, but rather appeared to be the result of an underlying emotional and psychological breakdown, likely influenced by the ongoing custody dispute. The loss of two young lives at the hands of their own mother left a community in disbelief and mourning, struggling to comprehend such a horrific betrayal of parental trust. Marilyn Edge was charged with special circumstances murder, a serious charge that leaves her facing either the death penalty or life in prison without the possibility of parole. As of now, she is awaiting trial in Orange County, where she is undergoing a psychiatric evaluation to assess her mental state at the time of the murders. This case remains one of the most heartbreaking examples of parental violence, serving as a stark reminder of the devastating consequences that emotional turmoil can have when left unchecked, especially when it results in the loss of innocent lives. Tiffany Hall. On September 15, 2006, Tiffany Hall, a 24-year-old woman from East St. Louis, Illinois, committed one of the most horrific and senseless acts of violence. Hall, who had grown up with the victim, Jamela Tuntal, and was trusted as a babysitter, brutally murdered her pregnant friend and her three young children. The tragedy unfolded when Hall beat 23-year-old Jamela Tuntal to death and then cut her unborn child from her womb. Following this, she drowned Jamela's three children, 7-year-old Demand, 2-year-old Ivan, and 1-year-old Janella, in an act of calculated cruelty. The sheer brutality of the crime shocked both the community and law enforcement, as a trusted figure in the victims' lives was responsible for their deaths. Tiffany Hall was arrested and charged with the brutal murders of Jamela and her children. She pleaded guilty to all 5 counts of murder, including the unlawful killing of the unborn child. On June 9, 2008, she was sentenced to life in prison without the possibility of parole, reflecting the severity of the crime. Hall remains incarcerated in Illinois, where she serves her life sentence. The murders of Jamela and her children serve as a chilling reminder of the depths of violence that can exist, even within relationships built on trust. The victims' tragic deaths left a deep scar on the community, and their memory endures as a heartbreaking story of loss and betrayal. Malikia Tamu Griffin. On May 18, 1999, Malikia Tamu Griffin, a chemistry graduate from Jackson State University, committed a senseless act of violence that ended the life of her 25-year-old neighbor, Jason Horsley. The dispute, which began over a disagreement involving tools, escalated tragically when Griffin shot Horsley in the back with a 9mm handgun equipped with a laser sight. Horsley, a carpenter, had been living in the same neighborhood as Griffin, but what should have been a minor conflict turned deadly as Griffin's anger led to a fatal attack. Griffin, who harbored extremist ideologies, fled the scene after the murder and went on the run, evading capture for nearly 6 years. During this fugitive period, Griffin's whereabouts remained unknown, and it wasn't until 2005 that she was finally apprehended in California, bringing her violent escape to an end. The authorities tracked her down, and she was arrested and extradited back to Colorado to stand trial for the murder of Jason Horsley. In 2006, Malikia Tamu Griffin was convicted of first-degree murder and sentenced to life in prison without the possibility of parole. The court recognized the severity of the crime and Griffin's potential threat to society. She is currently incarcerated at the La Vista Correctional Facility in Pueblo, Colorado, where she remains serving her life sentence. This case highlights how a seemingly small dispute spiraled out of control, ultimately resulting in the tragic loss of an innocent life. It also serves as a reminder of the dangers posed by extremist ideologies and the lengths some will go to when consumed by anger and hatred. Marie Dean Arrington. On April 22, 1968, Dean Arrington committed a shocking and violent crime in which she murdered Vivian Ritter, a 37-year-old secretary working for a public defender. The crime was rooted in deep resentment, as Arrington blamed the public defender, whose office Ritter worked for the convictions of her children. Arrington, who had a history of violent behavior, had previously shot her husband in 1964, further indicating a pattern of escalating violence in her life. On the day of the murder, Arrington shot Ritter with a .22 caliber revolver, taking the life of the innocent secretary. The cold-blooded nature of the crime led to Arrington being placed on the FBI's 10 Most Wanted list in 1969, marking her as a dangerous fugitive. In 1969, she managed to escape from the Florida Correctional Institution, prolonging her time on the run. However, her freedom was short-lived, and in 1971, Arrington was captured in New Orleans, ending her fugitive status. Arrington was tried and convicted for the murder of Vivian Ritter. She was initially sentenced to death, but in 1972, her death sentence was commuted to life in prison. Since then, she has remained incarcerated for her crimes. Dean Arrington's case is marked by a violent history, a high-profile escape, and a transformation from death row to a life sentence. Her story reflects the extreme lengths to which some will go in their anger and desperation, as well as the consequences of unchecked violence and resentment. She is still serving her life sentence to this day, a somber reminder of the far-reaching effects of her actions. Lutricia Dancy. On October 1, 2003, Lutricia Dancy committed a brutal crime in Miami-Dade County, Florida, when she murdered her 51-year-old husband. Dancy, who had led a quiet life prior to the crime, shot her husband and then took further disturbing measures to conceal the murder. After shooting him, she poured acid over his body and attempted to set it on fire, hoping to destroy any evidence of the crime. The murder went unnoticed for several days until concerned neighbors reported a strong, unpleasant smell emanating from the residence. Upon investigation, authorities discovered the remains of Dancy's husband, confirming the horrific nature of the crime and the lengths Dancy had gone to cover it up. Dancy was arrested and later convicted for the murder of her husband. On November 15, 2005, she was sentenced to 45 years in prison for the crime. She is currently incarcerated in the Florida Correctional System, where she will serve her sentence for the brutal and calculated murder. Her case stands as a chilling example of how a seemingly quiet life can conceal dark and violent actions, and how the desire to hide a crime can lead to even more disturbing behavior. Dorothy Williams. Between 1987 and 1989, Dorothy Williams embarked on a chilling killing spree in the south side of Chicago, targeting elderly residents living in senior housing. Over the course of these 2 years, Williams murdered at least 3 victims: Lonnie Law, age 79, Caesar Zuel, age 64, and Mary Harris, age 97, using methods of strangulation and stabbing. The murders were particularly horrifying due to the vulnerability of her victims, who were all elderly and living in precarious conditions. Born on December 24, 1954, Williams struggled with a heroin addiction, which likely played a significant role in her descent into violence. Her crime spree was marked by a disturbing pattern, preying on elderly individuals, some of whom were frail and unable to defend themselves. Her actions shocked the community and left residents of senior housing fearful for their lives. Williams was eventually apprehended and convicted for the murders. Initially sentenced to death for her crimes, her death sentence was commuted to life in prison without the possibility of parole in 2003, reflecting the evolving stance on capital punishment in the state of Illinois. Currently incarcerated in Illinois, Williams remains behind bars, serving a life sentence for her brutal and senseless killings. The case of Dorothy Williams serves as a haunting reminder of the dangers posed by addiction and the devastating impact of targeting vulnerable members of society. Lisha Latai Landram. On June 9, 2004, 16-year-old Lisha Latai Landram, along with her boyfriend, 21-year-old Rocky Almastica Jr., committed a brutal and senseless murder in North Tampa, Florida. Landram, who was a high school dropout and mother, violently attacked Emily Clemens, her boyfriend's ex-girlfriend, at the Amaretto Apartments. The attack was both brutal and prolonged. Clemens was beaten over 30 times with a hammer, metal pots, and a stereo boombox, in a shocking act of rage and jealousy. The vicious assault left Emily Clemens gravely injured. After the beating, she was discarded in a dumpster, left for dead. However, she was discovered alive by a passerby and rushed to the hospital. Despite efforts to save her, Clemens succumbed to her injuries and died later in the hospital, a tragic end to a life that had been violently cut short. Landram and Almastica were arrested for the crime, and Landram was convicted of first-degree murder. On February 20, 2006, she was sentenced to life in prison without the possibility of parole for her role in the murder of Emily Clemens. Currently incarcerated in Florida, Lisha Latai Landram will spend the rest of her life behind bars, paying for the senseless killing of a young woman whose life was tragically ended by jealousy and violence. The case serves as a haunting reminder of how unchecked emotions and rage can escalate into extreme acts of violence, leaving irreversible consequences for all involved. Tanya Thomas. On May 15, 2012, Tanya Thomas, a 33-year-old single mother from Port St. John, Florida, committed a devastating murder-suicide that tragically ended the lives of her 4 children, 12-year-old Joel, 13-year-old Jacine, 15-year-old Jax, and 17-year-old Pebbles. The act of violence was preceded by a text message Tanya sent, which read, "Tell my mom what happened. I want to be cremated with my children." This ominous message foreshadowed the horrific events that would follow. In the hours leading up to the tragedy, Tanya called her children home from a neighbor's house. Once they were inside, she shot each of them multiple times with a .38 caliber revolver, killing them in an act of incomprehensible violence. After the murder of her children, Tanya Thomas turned the gun on herself, taking her own life in the final tragic act. The case of Tanya Thomas is deeply haunting, as it illustrates the devastating consequences of unresolved domestic violence and the profound impact it can have on the lives of innocent children. Tanya had a history of domestic violence, which may have played a role in her violent actions. Her death, along with the murders of her children, left a community in shock and mourning. The warning signs, including the chilling text message, serve as a stark reminder of the need for awareness and intervention in situations of family distress. Ebony Passion Smith. On July 15, 2011, Ebony Passion Smith, a 32-year-old woman from Warner Robins, Georgia, committed a tragic act that ended the life of her husband, Brian Smith, a U.S. Air Force mechanic. The crime occurred after Smith was served divorce papers and feared losing custody of their daughter. Struggling with severe depressive disorder and psychotic features, Ebony's mental health issues played a central role in her violent response to the impending breakup. In a moment of intense emotional turmoil, Ebony shot Brian multiple times with his own .40 caliber Glock handgun, killing him in cold blood. After the murder, she attempted to take her own life by swallowing a large quantity of pills, likely in a state of despair over the aftermath of her actions. Ebony Smith was arrested and later convicted of murder. On August 7, 2013, she was sentenced to life in prison with the possibility of parole after 30 years. Her case reflects the devastating consequences of untreated mental health issues and the violent acts that can result when emotions are left unchecked. Currently incarcerated in Georgia, Smith will serve her sentence for the murder of her husband and the tragic disruption of her family's life. Latasha Cunningham. On May 18, 2011, Latasha Cunningham, a 37-year-old woman with a history of violent crime, committed a brutal murder and robbery in Collinsville, Illinois. Cunningham, along with her cousins Dee Coyne and DeMarcus Barnes, targeted 85-year-old Yoko Cullen, an elderly woman who had just finished playing bingo. The crime was driven by greed, as the trio sought to steal the $390 that Cullen had won from the game. The attack was both violent and senseless. Cullen was beaten with a tire iron, and then, in a horrific act of cruelty, she was placed alive into the trunk of a car, where she was burned to death. The brutal nature of the murder was confirmed when soot was found in Cullen's airways, indicating that she was still breathing when the fire began. The motive for the crime, an insignificant sum of $390, was a reflection of the depths to which Cunningham and her accomplices had fallen. The senselessness of the act was compounded by the fact that the victim, an elderly woman, was tortured and killed in such a violent manner. Latasha Cunningham was arrested and, along with her cousins, was convicted for her role in the murder. On December 11, 2013, she was sentenced to 60 years in prison without the possibility of parole for the murder and robbery of Yoko Cullen. Cunningham remains incarcerated in Illinois, serving her sentence for a crime that left a community shaken by the brutality and senselessness of the act. The case serves as a chilling reminder of the tragic outcomes that can result from greed and violence, especially when the victims are vulnerable members of society. Margaret Anne Allen. On February 8, 2005, Margaret Anne Allen, a woman with a troubled past, committed a brutal crime in Titusville, Florida. Allen murdered her housekeeper, Wenda Wright, in a violent and calculated attack. Allen, born in 1966, had grown up in a troubled neighborhood and had a history of arrests. Her actions on that day would add to her criminal record in the most horrific way. Allen, along with her accomplices, her nephew Quentin Allen and roommate James Martin, beat Wright severely, poured chemicals onto her face, and then strangled her with a cloth belt. The brutality of the crime shocked the community and left an indelible mark on the victim's family and friends. The investigation into Wright's death uncovered the chilling details of the murder, leading to the arrest of Allen and her accomplices. In 2011, after a trial, Allen was convicted and sentenced to death. The jury unanimously voted for the death sentence, highlighting the severity of the crime and the level of violence involved. Currently, Margaret Allen remains on Florida's death row, awaiting the execution of her sentence. Her case serves as a grim reminder of the deadly consequences that can arise from suspicion and rage, and the devastating impact of unchecked violence. Andrea Hicks Jackson. On May 16, 1983, Andrea Hicks Jackson committed a crime that would alter the course of her life and the life of Officer Gary Bevel, a 29-year-old police officer in Jacksonville, Florida. During an attempt to arrest Jackson, she fired 6 shots at Officer Bevel, fatally wounding him. The murder of Officer Bevel was a tragic and violent moment that left a profound impact on his family, colleagues, and the community. Born on February 26, 1958, Jackson's background and the circumstances leading up to the crime remain a part of her legal story. In the aftermath of the shooting, she was arrested and charged with the murder of Officer Bevel. Her legal journey was long and complex, with Jackson receiving 4 death sentences over the course of several years. However, each of these sentences was overturned by the Florida Supreme Court, raising questions about the fairness of her trial and the application of the death penalty in her case. In June 2000, Jackson was resentenced to life in prison without the possibility of parole. She has been incarcerated in Florida ever since. Despite her life sentence, Jackson became eligible for parole as early as 2009, although her parole status remains uncertain. The case of Andrea Hicks Jackson serves as a reminder of the emotional and legal complexities surrounding acts of violence, particularly in cases where the justice system's decisions can shift over time. Officer Bevel's death remains a somber chapter in Jacksonville's history, and Jackson's life sentence reflects the long-lasting consequences of that fateful day. Deborah Denise Brown. In the summer of 1984, Deborah Denise Brown, along with her partner Alton Coleman, embarked on a cross-state murder spree that spanned 5 states: Illinois, Indiana, Michigan, Kentucky, and Ohio. Together, they were responsible for the brutal deaths of 8 victims. Brown, born in 1962 as one of 11 children, had a history of developmental delays, with an IQ ranging between 59 and 74, and had suffered head injuries during her childhood, which may have played a role in her actions. The method employed in the murders was consistent across all the victims: ligature strangulation, a signature technique that became the hallmark of their crimes. The pair's violent rampage terrorized the Midwest, leaving a trail of tragedy in their wake. In the aftermath of their arrest, Brown was convicted for her involvement in the murders. In Ohio, she was sentenced to death, a sentence that was later commuted in 1991. However, in Indiana, she received a separate death sentence, where she remains the only woman on the state's death row. Currently incarcerated at the Ohio Reformatory for Women, Deborah Brown serves her time for her role in the murders, having been involved in one of the most infamous cross-state murder sprees in the United States. Lashuan Terres Harris. On October 19, 2005, Lashuan Terres Harris, a 23-year-old former nursing assistant, committed a horrific act that would forever change her life and the lives of those around her. Struggling with paranoid schizophrenia, Harris took her 3 young sons, Trayon, aged 6, Toronto, aged 2, and Joshua, aged 16 months, to Pier 7 in San Francisco Bay. In a heartbreaking sequence of events, she dropped each child into the cold waters of the bay, where they tragically drowned. Harris, who had been diagnosed with paranoid schizophrenia, had a history of mental health struggles, which played a significant role in the crime. She had been experiencing delusions and profound distress at the time of the incident, which led to her devastating actions. Despite the tragic nature of her crime, the court determined that Harris was not fully in control of her actions due to her mental illness. She was found guilty of the murders but declared legally insane, meaning she was not held criminally responsible for her actions. As a result of her mental state, Harris was committed to a state mental hospital for life, where she remains to this day. Her case highlights the complexities surrounding mental illness and its potential to lead to violent actions. The deaths of her children, whose lives were cut tragically short, serve as a stark reminder of the profound impact mental health issues can have on individuals and their families. Lolita Barthol. On August 18, 1995, Lolita Barthol, a 17-year-old student from Tampa Bay Tech, became involved in a violent home invasion that would forever change her life and the life of Richard Mendez, a 64-year-old floral supply salesman. Barthol, alongside an accomplice, entered Mendez's home with the intent to rob him. However, the situation quickly escalated when a struggle ensued during the attempted robbery. In the heat of the confrontation, Mendez was shot, ultimately losing his life to the senseless violence. Barthol's youth made the crime even more tragic, as she was only 17 at the time. Despite being a juvenile, she was tried as an adult due to the severity of the crime. The case became a focus of debate on the legal handling of young offenders involved in serious crimes. The prosecution argued that the brutality of the murder and the calculated nature of the robbery warranted an adult sentence, while the defense pointed to her age and potential for rehabilitation. However, the jury convicted Barthol of both first-degree murder and robbery, leading to a life sentence without the possibility of parole. On December 19, 1996, Barthol was sentenced to life in prison. She is currently incarcerated at the Jefferson Correctional Institution in Tallahassee, Florida, where she remains behind bars, serving the life sentence handed down to her at the time of her conviction. Barthol's case highlights the complexities surrounding juvenile crime and the legal system's approach to such offenses. The tragic death of Richard Mendez and the consequences of Barthol's actions serve as a grim reminder of how quickly a life can be taken in the heat of a violent act. At just 17, Barthol's future was forever altered by a moment of impulse, resulting in irreversible consequences not only for her, but also for the victim and his family. Jacqueline Annette Williams. On November 16, 1995, Jacqueline Annette Williams, alongside her boyfriend Fidel Kefi and cousin Lever Ward, committed a heinous crime in Addison, Illinois, resulting in the brutal murders of a pregnant woman and her 2 young children. The victims, 28-year-old Deborah Evans, her 10-year-old daughter Samantha, and her 7-year-old son Joshua, were violently killed by the trio. Their motive was chilling: theft of Deborah's unborn child. Williams, born on December 22, 1966, had spent months faking a pregnancy, and her twisted plan was to steal Deborah Evans' baby after killing her. She, Kefi, and Ward carried out the murders with horrific violence. Deborah was killed along with her children, while the 2 surviving children, 2-year-old Jordan and the newborn Elijah, narrowly escaped death. The murder of Deborah Evans and her children was a tragic and senseless act that devastated the family and shocked the community. Williams and her accomplices were arrested and later tried for their roles in the murders. In 1998, Williams was convicted and sentenced to death, reflecting the severity of the crime. However, in 2003, her death sentence was commuted to life without the possibility of parole, and she remains incarcerated in Illinois, serving her sentence for the brutal killings. This case stands as a chilling reminder of the extreme lengths to which some will go to fulfill selfish desires, and the unspeakable toll it takes on innocent lives. The lives of Deborah Evans and her children were senselessly cut short, and their story remains one of the most disturbing examples of murder for the most depraved of reasons. Muriel Bemis. On February 23, 2014, Muriel Bemis, 21-year-old woman from Stone Mountain, Georgia, committed a heartbreaking act that would forever alter her life and the life of her 3-year-old daughter, Layla Bemis. Despite portraying a happy and fulfilling life on social media, the reality behind the scenes was far darker. Following an argument with her boyfriend over text messages from another woman, Bemis's emotions spiraled into violence. In a moment of rage, she suffocated her young daughter with a pillow, taking Layla's innocent life. In the aftermath of the murder, Bemis made a chilling confession to her boyfriend, saying, "I killed her." The sudden and tragic loss of Layla, coupled with the disturbing circumstances of her death, left a community in shock and grief. Muriel Bemis was arrested and later pleaded guilty to felony murder for the death of her daughter. On September 11, 2014, she was sentenced to life in prison for her crime. Currently incarcerated in Georgia, Bemis will spend the rest of her life behind bars, serving a sentence that reflects the severity of her actions. This case stands as a tragic reminder of how domestic disputes, when left unchecked, can spiral into irreversible violence, leading to the death of an innocent child. The loss of Layla Bemis remains a haunting example of the devastating consequences that can arise from unchecked anger and poor decision-making. Yvette Taylor. On February 11, 2012, Yvette Taylor, a 47-year-old woman with a criminal history, brutally murdered her elderly roommate, Theodore Crew, at the Applecross Apartments in Martinez, Georgia. Crew, 63, was found with sharp and blunt force injuries, the result of an assault that Taylor later admitted to, though she denied causing his death. Taylor's background revealed a troubling past, including a 1991 manslaughter conviction related to her brother's death. On the day of the murder, Taylor attempted to cover up the crime by cleaning the scene with bleach and water, hoping to erase any evidence of the violence that had taken place. Despite her efforts to conceal the crime, the investigation uncovered the truth, and Taylor's confession came shortly afterward, though she minimized her role, stating, "I cut him. I admit that, but I didn't kill him." After a trial, Yvette Taylor was convicted and sentenced to life without the possibility of parole in February 2013. This case underscores the tragic outcomes that can arise from violent outbursts, especially when compounded by a history of prior violent offenses. The death of Theodore Crew, an elderly man, reflects a senseless act of violence that resulted in a loss of life and left a community grappling with the shocking events.
She did not become a suspect until the investigators who were talking to her compared with the other investigators who were talking to the other witnesses. And the stories didn't mesh. Timelines didn't mesh. Nothing meshed. So instead of believing that the neighbors and the mama conspired to falsely provide evidence, they figured that it must be the one person conspiring alone to provide help for herself. There is only one answer to the question. Who killed the victim? She sees right.
Latasha Pulum. On March 21, 1991, Latasha Pulum, then just 19 years old, committed one of the most horrific crimes in Chicago's South Side, alongside her boyfriend, Dwight Jordan. Together, they abducted their 6-year-old neighbor, Shenosha Richards, and subjected her to prolonged torture and sexual assault before ultimately taking her life. The brutality of the crime shocked the community and left a lasting scar on the local residents and Shenosha's family. Latasha Pulum, born in 1971, had a troubled background, and her actions that day would forever alter her life. The details of the crime were chilling. Shenosha was subjected to relentless abuse, and her life was cruelly extinguished after hours of suffering. Pulum and Jordan's actions were marked by a level of violence that was both premeditated and cruel, with Pulum later delivering a chilling confession that was described as being made with an unsettling level of calm. The crime was so horrific that a state expert would later describe Pulum as a female John Gacy, a comparison to the infamous serial killer due to the severity and nature of her crime. In 1992, Pulum was convicted of first-degree murder and sentenced to death for her role in Shenosha's tragic death. However, in 2003, her death sentence was commuted to life in prison without the possibility of parole. Tvasha Logan. On November 1, 2009, 25-year-old Tvasha Logan, a mother of 6, committed an unfathomable act, that led to the starvation death of her 5-month-old daughter, Chantasia Gardner, in Lakeland, Florida. Logan, who had been responsible for her children's care, intentionally diluted baby formula by mixing it with 3 parts water, depriving her infant daughter of the essential nutrients needed for survival. This devastating act of neglect caused Chantasia to starve, and at the time of her death, the baby weighed only 6 pounds, less than her discharge weight from the hospital after birth. Logan's boyfriend, Chanty Gardner, was also charged in connection with the crime. It was revealed during the investigation that both Logan and Gardner were responsible for the infant's suffering and eventual death, though the extent of Gardner's involvement remains a subject of legal scrutiny. The details of the case shocked the community, with the loss of an innocent life due to extreme neglect. Logan was convicted and sentenced to life in prison without the possibility of parole on July 11, 2012, for the murder of her daughter. She is currently incarcerated in the Florida Correctional System, serving her sentence for a crime that left a family devastated and a young life tragically cut short. This case highlights the horrific consequences of neglect and the vulnerability of children, whose lives can be irrevocably altered by those entrusted with their care.
Judge Lina Hidalgo publicly announced a leave of absence to receive inpatient treatment for clinical depression following several months of care. She returned to her duties while continuing weekly group therapy sessions every Thursday from 3 to 4:30 p.m. The commitment was openly acknowledged when county commissioners voted to move their regular meetings from Tuesdays to Thursdays during a recent court session. Scheduling conflicts emerged once again as the Thursday afternoon time slot interfered with Hidalgo's ongoing treatment. In response, Hidalgo reminded the court that her therapy was not optional, emphasizing that mental health care is medical care and should be treated with the same seriousness as any other condition. In a firm statement, she explained that her attendance in therapy could not be delegated nor rescheduled, warning that minimizing its importance could send a harmful message.
As you guys know, I have to take a break between 3 and 4 o'clock. I have my group therapy. We knew this when we rescheduled court for Thursdays, and so that was my asterisk when we decided to move court to Thursdays. So
I'm not, and again, Judge, just a quick question. That 3 to 4 is an important hour. What can we do 3 to 4?
The discussion can continue, right? So Commissioner Ellis runs the meeting, and then you guys can continue the meeting. Oftentimes, somebody's late, we just do that, we discuss. All I ask is that, as I've done when one of you guys is absent and coming back, that you not take the votes and wait until I return to take the votes.
So, Judge, I'd like to suggest, and if there's latitude to do it today in the rules, I'd like to change it today, and if not, do it on the next court. When I was in the legislature, and someone had to walk out of the room, we gave people permission, it's in the rules of the Senate, so you could cast your vote when you got back, as long as it did not change the outcome of the vote. If I'm not mistaken, Jay, I know you were there as an intern a long time ago. I think you worked there for a while. But I think that would be good in our rules. Sometimes I may have to walk out, or anybody may have to walk out. And if it changes the vote, that's a different deal. But it would give any one of us the ability to walk out of the room, do whatever you have to do, come back. Am I right, Jay? Am I remembering this right?
No, that's correct, Commissioner, and we can certainly do that. I think for the next meeting, I've already spoken to the county administrator about it. We can make a change to the rules that will expedite that process. Unfortunately, I can't do it for this meeting because there's not a rules item on, but we can certainly have it ready for the next court.
Yeah, and what happened last court that was time consuming is that the court voted while I was gone. Whenever I'm presiding over the court, what makes it quick, and the reason maybe you guys don't remember this, is because I hold the vote. So we discuss, and then once somebody returns, then I say, okay, let's vote on item 3, and we don't have to say let's vote on reconsidering the vote and now let's vote. So if you will extend that courtesy to me of holding the vote until I return for this court, it'll be a lot easier.
So what I'm saying is, if we tweak our rules,
right? So he's going to tweak them for next time.
Yeah.
But he's saying he can't tweak them for this time.
Yeah. If we move expeditiously today, when I looked at the agenda, I think we ought to finish this by 3. We ought to finish it by 2.
And I agree, and I'd even be interested in seeing how much time each of us speak to see who's holding up the meeting, because I know we've tried to cut back on speakers, and really it's the speaking here on the dais. So maybe we'll have someone run that down. All right, so we're gonna invite our public speakers to address the court, and thank you again for taking the time to be here. So Tiffany, if you would please introduce our speakers.
Judge, I think you got
Yes.
folks in the queue.
Oh, Commissioner Ellis, Commissioner Briones, and then Commissioner
I
Garcia.
spoke, I'm sorry.
Thank you.
So County Attorney's Office, similar to what Commissioner Ellis just said, my ask, to the extent permissible, would be a both and, right? So if somebody has an appointment or another commitment that they need to leave, that they be afforded the opportunity to vote when they return. And meanwhile, those who remain can cast their vote as we're discussing things, because it's highly disruptive to go back item by item. And so if we can both and this, so that we can allow flexibility, but also allow maximum efficiency and focus, that would be my strong preference, please.
And that's what Commissioner Ellis explained. That's what I'm talking about. This is what extends the discussion. We already agreed on that. Commissioner Garcia.
I walk into these meetings with my day planned, and so today I've already got commitments. If we kill an hour without anything productive, it really sets my schedule up. So I will also like some consideration for my schedule, not knowing that we're going to take an hour out during court meetings, and so I would just say if we can. We're going to change the rule next court. If we happen to go into the 3 o'clock hour when you're gone, I would just ask if we could just take votes, and then it's going to be one court. We'll be able to move forward the court after.
Yeah, and you can do that, Commissioner. I'll make sure not to extend that courtesy in the future. But really the concern is, court used to be on Tuesday. The court decided to move our meetings to Thursdays. And so this is not a commitment that came up for me out of nowhere. I did my mental health leave in 2023. I was inpatient for anxiety and depression for 8 weeks. I've been very public about that. And since I returned, I've been doing my group therapy on Thursdays from 3 to 4:30. So when the court said they wanted to move our meetings to Thursday, I said, I have this standing committee, well, I guess it could be a committee, it's a group, the standing commitment that is part of my mental health treatment. So I would just like to underscore that's you, joining the ranks of those who are trying to pick on me over mental health treatment.
Please, we're not going to go there. Look, I got put on the planning commission that is on Thursdays. We moved the court to Thursdays. I can't make all the planning commission meetings, so I have my proxy there. And we're able to continue the business.
I can't send a proxy to my mental health treatment. Yes, Commissioner. Let's just move on. Okay, if you want to have the vote without me, have the vote without me. I'll remind the community that you are interfering with something that I'd mentioned before. And people can see that. People can see your behavior, and I frankly think it's embarrassing, but that's okay. All right, let's move on.
The issue sparked broader discussion among county leaders about balancing governmental efficiency with compassion and understanding, particularly when it comes to public officials navigating mental health challenges, while some members of the court raised concerns over timing. Others voiced support for maintaining her schedule without interference. Hidalgo reiterated her commitment to serving the public, while also prioritizing her recovery. As the conversation continued, the case served as a public example of the tensions that can arise when personal health and professional responsibility intersect, reminding many that leadership includes modeling vulnerability and care for one's well-being. Susan Lorincz, on June 2, 2023, a long-standing dispute between neighbors in Ocala, Florida, turned deadly when 60-year-old Susan Lorincz and killed 35-year-old Ajiki A.J. Owens through her locked front door. The conflict reportedly began over Owens's children playing near Lawrence's property and had escalated over time that day after a heated verbal exchange. Lawrence fired a single round as Owens knocked on her door. Owens later died from her injuries. Lawrence was arrested, charged with manslaughter and assault. claiming she acted in self-defense and feared for her life. Prosecutors argued the shooting was not about fear, but frustration, highlighting that no direct threats were made during the confrontation.
Jared Gardner told you that he heard Miss Owens say, after she banged on the door, something to the effect of, "Come out here," or "Open the door," something to that effect. Jared Gardner told you he never heard Miss Owens say anything like, "I'm going to effing kill you," "I'm going to break down your door," "I'm going to go in your house." He didn't hear anything like that, because those statements weren't made. He heard Miss Owens tell the defendant, "Come outside." You heard from Muriel Rodriguez, 12-year-old Muriel Rodriguez, the second witness we called. He told you he saw Miss Owens walk across the street, saw her walking with a purpose, saw that she was angry, it was clear how she was walking, saw she didn't have anything in her hands. He heard Miss Owens say, "Come out." And he said she used the B word and the F word, consistent with what Jared Gardner said. So he too hears Miss Owens say, "Come out, bitch." Ariel Rodriguez said he never heard Miss Owens threaten the defendant, say, "I'm going to effing kill you, I'm going to bust in your house," anything like that. It was "come out." Miss Owens made it clear to the defendant that she wanted the defendant to come out and deal with this situation. If Miss Owens wanted to get into that house, all she had to do was take something from the patio, that little Santa thing that was sitting there, throw it through the sliding glass door, shatter the door, and get in there. She didn't do any of that, because her goal was not to get in the house. It was to get the defendant to come out and deal with the situation with her children. Even in the defendant's interview with the detectives, she was asked what was the first thing that came out of Miss Owens' mouth. And the defendant said, Miss Owens first said, "I want to speak to you because you're talking to my sons. I don't like the way you're talking to my sons." First thing out of her mouth deals with her sons. First thing out of her mouth is not, "I'm going to bust in your house and I'm going to kill you." It's, "I want to talk to you about my sons," just like the last times. You heard from Yvonne Costa, who's the neighbor, had the joining wall to the defendant's apartment. She told you that she heard arguing, loud arguing, and then she heard a door slam. Clearly, this was the defendant slamming her door after she was arguing with the children, because Yvonne Costa said a few minutes later is when she hears the pounding. And the pounding was loud. There's no doubt about that. It was loud enough to shake the wall between the two of them that they share, and maybe even rattle a mirror. It was loud. But it wasn't banging hard enough to damage the door. There's no dents. There's no major problems with the door. No damage to the doorknob as if someone was trying to beat on it and break the doorknob off to get in there. She was banging hard like law enforcement officers do when they come to a door and say, "Marion County Sheriff's Office." And in fact, the defendant actually told the detectives she initially thought it might be the law enforcement coming. Why? Because she just called them and knew they were coming. She knew they were coming before she shot. Everyone then, after the banging, hears the shot. You heard the interviews the defendant gave and the 911 calls. The defendant never said that Miss Owens was rattling her doorknob, shaking the doorknob as if she was trying to get in. She was specifically asked during the second interview, did she ever try to open that sliding glass door or open the door handle or anything like that, or was it just pounding? The defendant's answer was, "I just remember her pounding and pounding." You also heard in the interview that the defendant gave that the sliding glass door was further secured by a wooden stick in the track, so the door couldn't be opened. It was locked, the door couldn't be opened because of that wooden stick. The defendant never told the detectives during the interviews that Miss Owens was trying to open that sliding glass door, that she was banging or jiggling on the doorknob trying to get in. Never told them that she was trying to break her window or anything like that. Rather than wait for law enforcement to arrive, because she knew they were coming, because she called and they told her that law enforcement was coming, she went into her bedroom and grabbed her phone. She doesn't grab her phone, which she just had in her hand 2 minutes earlier, to call 911 again. She goes in the bedroom and grabs her phone. She goes back into the family room. She approaches the door to the point where she says she reached that kitchen table. She doesn't fire a warning shot through the door or in the air, into the ground, anything like that. We heard her in her first interview say she never intended to kill Miss Owens. Well, look at the placement of the shot that she fired. She took aim, she leveled that gun at the door. She aimed directly where a person would be if the person was knocking on the door, at a height consistent with where Miss Owens would be, and pulled the trigger. She didn't fire over and over and over again. She didn't unload her magazine as if she was in a panic. She fired one controlled, precise round into the door at the exact place a person would be if they were knocking. Then she had the presence of mind to go back into her bedroom, put that .380 Remington back in the trash can, underneath the .22 caliber Ruger that was found. Because remember, CSI Medina found the .380, the shot that used to fire the bullet in this case, beneath the .22 caliber Ruger, the little plinker. And then she has the presence to call 911. So now that we know what the evidence has shown, let's go back to the instructions that we looked at earlier. The circumstances that she found herself in when she fired that round were that she was angry at Miss Owens' children, such that she called 911 on the children. That an angry mother was banging on her door, yelling at her to come outside. That she is behind a closed, locked, deadbolted metal door, and she knows law enforcement is on the way. She goes into her bedroom, she grabs her gun, walks back to the living room, walks towards the door, fires one precise round in the exact location where a person would be. Those are the circumstances by which she was surrounded when she made that decision to pull the trigger, at the time she decided to use deadly force. There was no imminent danger whatsoever when she fired that gun. Miss Owens had not broken down the door. She hadn't gained access to her house. She hadn't shattered the sliding glass door to get in. Miss Owens was banging on the door, telling the defendant to come out. A belief that there was an immediate or imminent danger such that deadly force was necessary at that time was simply unreasonable, because there was no imminent danger. And that word imminent is very important. It's included in the law for a reason. In order for the defendant to be allowed to use deadly force, that threat to her life must be imminent. It had to be ready to happen. It had to be staring her in the face, such as she had to act at that moment to protect her life. If Miss Owens would somehow have managed to bust through this locked, deadbolted metal door, entered her house, and started coming at her, the defendant may have had a right to shoot, because that danger would have then been imminent. But that's not the situation we have here. We talked about Part A, imminent death or great bodily harm to herself. She would also have the right to use deadly force if she needed to do so to prevent the imminent commission of a burglary, murder, or aggravated battery against herself. Murder is defined as the intentional, unlawful killing of another by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Again, there's no evidence to support that at the time the defendant fired that gun, that Miss Owens was about to murder her. Miss Owens had no ability whatsoever to even get into that house, to even try to cause her harm. There is the secure, locked, deadbolted metal door.
The case quickly gained national attention, drawing focus on race self-defense laws and neighborhood conflict. The trial began in mid-2024 and included testimony from neighbors, police, and forensic experts. Jurors reviewed audio from the incident and 3D reconstructions of the scene. In November 2024, the jury found Lorincz guilty of manslaughter at sentencing. She addressed the court, expressing remorse in a written statement to Owens's family, saying she never intended to kill her judge.
And it's one of the reasons why I had issues with the gentleman I was with, because he wanted to have another child, and I felt I was stopping him. That said, I would like to make a statement to AJ's mom, children, and friends. It is with heavy heart and great remorse I write this letter to you. First and foremost, I am so sorry that I took AJ's life. I never intended to kill her. The night I shot that gun, I was confused as to why she was screaming and pounding on my door. I had an idea that Israel told her I had hit him. I could not understand why she was so angry. And she truly scared me. Now that I know he told her I hit him,
I am just profoundly sad. Not only did a mother die, but a daughter and a sister. I think of your family's loss and know how hard it is to lose someone you love. How being able to see that person, look at that person, or just talk to that person is such an empty feeling. I so wish I could go back and change things so that she was still here. I would trade my life so that she could be here, if it were possible. I know that you have all suffered from her loss, and I have prayed for you and your family during this time so that you can, that God could help you. Nothing I can do will change the outcome. I can only tell you I have cried and I feel horrible for my actions. Please accept my humble and sincere apology for this tragedy.
Robert Hodges sentenced Lorincz to 25 years in prison, citing her mental health history. But ultimately, concluding her actions were driven by emotion, not necessity. Maxwell Anderson, on April 1st, 2024. 19-year-old Sade Robinson, a college student with dreams of working in criminal justice, met 33-year-old Maxwell Anderson for a first date in Milwaukee. They were seen dining together at a local restaurant before returning to Anderson's apartment. Later that evening, surveillance footage and cell phone records confirmed their movements that night. Sade never came home in the days that followed. Her disappearance sparked a citywide search, and investigators began piecing together what happened. Forensic evidence and witness testimony pointed to a violent encounter inside Anderson's residence. Prosecutors detailed how Sade's life was brutally taken and how Anderson attempted to cover up the crime. The defense argued for delays in trial, citing complex discovery and ongoing analysis of forensic material. But the prosecution pressed forward, describing Sade as a dedicated student and hard worker, whose life was cut short by someone she trusted. On June 6, 2025, after less than an hour of deliberation, the jury found Maxwell Anderson guilty on all counts. Sentencing was scheduled for August 1st, while a separate civil case brought by Sade's family is set for August 15th. The courtroom heard how a young woman full of ambition and promise left for a first date, never knowing she wouldn't return. The case left a lasting mark on the community and served as a chilling reminder of how quickly trust can turn into tragedy.
I'm asking that this demon be respectfully returned back to hell as soon as possible.
Took her body down to the shores of Lake Michigan. He cut her up into pieces and disposed of her in the lake, mostly in the lake.
How can someone get to a point of inflicting such damage on a person? Not only killing the person, but then dismembering. And then after that, discarding the body throughout the community.
Hannah Payne, in Clayton County, Georgia. A tragic encounter between 21-year-old Hannah Payne and 62-year-old Kenneth Herring would become one of the most debated criminal cases in the state. It began on an ordinary afternoon when Payne witnessed a minor traffic accident involving Herring and a semi-truck. Instead of stopping, Herring drove away. Payne immediately called 911, reporting what she had seen. The dispatcher gave her clear instructions: stay where you are and let police handle it. But Payne chose a different path. She followed Herring for nearly a mile, eventually maneuvering her Jeep to block his vehicle. According to multiple witnesses, Herring remained inside his car in a defensive posture, showing no aggression. Payne, who was legally licensed to carry a firearm, approached with her gun drawn. Moments later, a struggle broke out at the driver's side window, and in that brief, chaotic moment, Herring was shot. He died at the scene. The case drew intense scrutiny, with many questioning whether Payne's decision to intervene was a reckless overstep or a justified attempt at a citizen's arrest. At trial, prosecutors portrayed Payne as an aggressor who ignored law enforcement orders and escalated the situation. The defense countered, arguing she acted in self-defense, fearing Herring might harm her. Jurors deliberated for just 2 hours before returning guilty verdicts on every count: malice murder, felony murder, aggravated assault, false imprisonment, and possession of a firearm during the commission of a felony. The judge sentenced Payne to life in prison with the possibility of parole, plus additional consecutive time for the other charges.
Judge, that is true. When we started this case, I think you came in with a narrow approach of it, not to let the media try to guide your understanding of what was going on. Came with an open mind, open eyes, wanting to see what was going on. And throughout the course of the trial, there were inconsistencies. I mean, the state's saying it was with my client. I'm saying it was with their witnesses. I don't think we heard really anything from the witnesses that matched up with what we could conclude happened. And during that process, there were lots of things brought up and a lot of unnecessary biases added to their statements. As for disrespectful, I felt the witnesses were disrespectful. I don't think any of the witnesses gave the respect they should have to the court and to the court officers. But that's part of what happens when you're in a trial. As for Ms. Payne, I think you heard her on the stand when asked, is there anything you could go back you would change? And she kind of dropped her head and said, you know what? I wouldn't even helped out at the beginning. I would not have listened to that state officer and tried to help out. And that's a shame that somebody who has good in their heart is no longer ever going to want to help anybody because, for lack of a better saying, no good deed goes unpunished. But that was a decision she made, and a decision that, her upbringing, her standards, her values put her in that situation. And that decision is what got us here today. And that decision, according to the jury, is wrong. And just because it was a bad decision doesn't make her a bad person. It just makes her human. And we all are human. And she is young in age. And I believe the state's assessment is correct about what charges would merge with which ones. With malice murder, even though we'd agree to disagree, I just did not hear elements that would do that, and maybe it's because I know Hannah from the 4 years we've been preparing for this. But to give her life without parole is to take a person who had good in her heart and tell her you'll never get a chance to get back out and get that good back. So we would respectfully request that the court look back at what all was said, look back at what all was done and was brought forth, and fully understand she never intended anything that day when she left from work to end up being there, to be in a struggle with Mr. Aaron, to be on the side of the road, to have to pull her gun to protect herself and the gun going off. There was never any intent to have that. It was an accident. And by the grace of God, when it did, she wasn't shot by it, and it was terrible and a tragedy that Mr. Herron was. But, she is a young person who has plenty of life ahead of her. We just hope that the court would use the discretion to allow her to have some of that life to continue. The charge number 5, the false imprisonment, it does say it could be run concurrent or it could be run consecutive, but it also says it can be probated. And the 5 years for the gun can be probated. And I think the court would hopefully look into what has been said today from both sides. Unfortunately, I was not able to speak with the jurors to see what their mindset was, to find out conclusively, was it dead set because the facts were overwhelming, or was it something they discussed? So I really can't go into details of what the jury said. I just can go in what I heard and wrote down, and I saw you making numerous notes. And I would hope the court would use those notes in coming to the decision to sentence her to life with parole and allow the other two, the one charge to be run concurrent, the other one has to be consecutive. Our hands are kind of tied on that. But understand that, this was all done with good intentions. And I know they say the road to hell is paved with good intentions, but she's never seen that road. She's never seen what happens out there in car accidents and arguments and walking up on cars in Clayton County. And to sentence somebody to life without parole for being naive or trying to do something with the goodness of a heart, I think is a little bit harsher than what is necessary in this case. And I would just put it to the court to use the facts that they've heard and the direction that is given to them by the law and the compassion that we know is in your heart, and allow her to have parole and have an opportunity to show that it was just a bad decision. She's just human. Decisions can be changed by the way people handle adversity, which is what she's going to be dealing with here, and give her a chance to show that she does have good in her heart and that she does know certain things you can't do. And no matter if it feels right to do it, you just can't do it. And I don't think she'll ever step up to help again. And that's a tragedy in itself, not to the magnitude of losing a loved one. But if the court could take that in consideration of her age, the facts, the compassion, and sentence her to life with parole and have the other charge run concurrent and probate that gun charge, I think it would allow her time to reflect, to fully understand that things happen and it can be found to be wrong, but it's how you handle yourself through that adversity to get through it and come back and show the true you is what allows us to keep hope in our heart and allows us to keep going. Thank you, Your Honor.
Thank you, Attorney Tucker. Mr. Foreperson, if you would go ahead and read the verdict.
With regard to count 1, as to the offense of malice murder, we, the jury, find the defendant guilty. With regard to count 2, as to the offense of felony murder, we, the jury, find the defendant guilty. With regard to count 3, as to the offense of aggravated assault, we, the jury, find the defendant guilty. With regard to count 4, as the offense of felony murder, we, the jury, find the defendant guilty. With regard to count 5, as the offense of false imprisonment, we, the jury, find the defendant guilty. With regard to count 6, as to the offense of possession of firearm during commission of a felony, we, the jury, find the defendant guilty. With regard to count 7, as to the offense of possession of firearm during commission of a felony, we, the jury, find the defendant guilty. With regard to count 8, as to the offense of possession of firearm during commission of a felony, we, the jury, find the defendant guilty. Respectfully submitted, the 12th day of December 2023.
All right, I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, it will.
Okay, go ahead.
On January 21st, 2025, at 12:32 p.m., Officer Aguilar was dispatched to 19380 Allen Road, that's Drink Saloon in Brownstown, regarding a larceny of a wallet. Upon Officer Aguilar's arrival, he spoke with our victim in this case, Miss Kaylee Wilhelm, who works at Drink Saloon as a waitress. Ms. Wilhelm stated that on Saturday, January 19th, while at work, her wallet went missing. Ms. Wilhelm was unable to locate her wallet at home, so she informed the manager on the January 21st. Victim Wilhelm explained that she and most waitresses placed their wallet and purse and personal property on the far west end of the counter inside of the restaurant. Ms. Wilhelm was able to review surveillance cameras and found footage of a female and a male that can be seen near that part of the counter. The unknown female at that time and male can be seen grabbing the wallet and passing it over to the male, who then stuck the wallet down the front of his pants. That day, the male paid his bill with a credit card and the receipt. It was shown to belong to the name Jordan McKinney. Ms. Wilhelm stated that she looked up the name on Facebook for that account and located the male's account on Facebook. Using this information, Officer Aguilar was able to confirm the male's identity with the use of Lean SOS as Jordan Durain McKinney. Officer Aguilar made contact with Mr. McKinney on the telephone. McKinney stated he was at Drink Saloon on the January 19th with a female he had just met there. Officer Aguilar told McKinney about the situation and asked him if he knew anything about the stolen wallet, which he denied at that time. Officer Aguilar explained to him that there was video footage of him receiving the wallet from the female he was with and then sticking the wallet down his pants. McKinney then stated that the female asked him to hold the wallet. He did not know that it was stolen. McKinney then told Officer Aguilar he believed the female's first name was Octavia. McKinney later told Officer Aguilar it was his coworker and that he had a phone number for the female. McKinney stated he gave the wallet back to Octavia once they exited the establishment. Officer Aguilar then made contact with the female, Octavia Abercrombie. Miss Abercrombie stated that she was at Drink Saloon with McKinney, but did not steal the wallet to Officer Aguilar. Video surveillance from Drink Saloon was gathered during his investigation. Our defendant, Miss Abercrombie, can be seen reaching over the counter, grabbing the wallet, then hands the wallet off to McKinney. McKinney grabs the wallet, puts it down in front of his pants. Signs all over the doors. January 29th, Detective Attard contacted our victim in the case via telephone. Victim advised that her wallet was recovered in a garbage can in the female bathroom on January 23rd, and everything that was stolen was in the wallet. Only the money was missing from her wallet. Victim believes she had somewhere between $300 and $400 inside of her wallet at the time it was stolen. On 1/29/25 at 11:49 a.m., Detective Attard contacted defendant Abercrombie via telephone. Defendant Abercrombie immediately confessed without being questioned to stealing the wallet from the bar and taking the cash out of the wallet and throwing it into the garbage in the women's bathroom. Defendant Abercrombie stated that there was only $170 in the wallet and explained that she had spent the money over the last several days on groceries and rides to work. Detective Attard asked about McKinney's involvement in this incident. Defendant stated that he did not know the wallet was stolen and did not receive or take any of the money in the wallet. On January 29th at 12:04 p.m. hours, Officer Attard contacted Mr. McKinney via telephone. McKinney stated he did not know the wallet was stolen and later gave it to defendant Abercrombie because he felt that it was unusual to just be told to hold the wallet. McKinney later found out defendant Abercrombie had stolen the wallet. McKinney stated he was not aware initially. What happened is stated he was not assisting Abercrombie in committing this crime. Items stolen during this incident was a black purse value of $150, $400 cash, unknown denominations, a Drink Saloon gift card, $42, Michigan driver's license, 2 debit cards, and 1 credit card.
Based on your testimony, I find the crime of larceny in the building as well as the crime of larceny. Less than 200 was committed. There's probable cause to believe the crimes were committed by the defendant. I'm going to authorize the issuance of the complaint. I'll note you signed the complaint and dated it yesterday. You sent it over, and then I'm just changing the date to today's date. Have a great day. Sorry about delaying getting out here. My apologies. Thanks.
Take care. Thank you.
Your name?
My name is Felicia Morris. Simon G is my daughter.
Yeah, I got the note. I'm going to go ahead and adjourn it. She's going to have to bring proof.
Yeah.
She's going to have to bring proof.
Okay.
So I will, I need another page of a register, second page. We're gonna give you a new date. Lisa, I'll just let you figure out the date down the hall there, whether it's, I'd like to do it next week anyway, okay?
Okay, we'll do the 14th.
All right, so we'll give you a copy of the notice. Good luck with all of that, okay? Thank you. Good luck, you too.
Good morning, how are you?
I'm doing all right. How about yourself? I don't usually see people coming to court so bubbly. It's good to see. But you got to slow down though, okay?
I know.
You're going to slow down, right?
Yes, I promise.
Okay, because if you don't, next time you come here, I can't give you impeding, okay?
I know.
So that charge of impeding traffic, responsible or not responsible?
Irresponsible.
Irresponsible? Is that what you said?
Responsible?
Responsible?
Yes.
Okay,
I'm
just kidding.
Okay.
All right, 170 is your total.
Okay.
I'll dismiss the traffic signal. You can go down the hall and take care of that. Good luck.
Thank you so much. Have a good day.
You too. Thanks. Brock, Marquetta Denise Brock, 25T645906. Good morning.
Good morning.
Your name?
Marquetta.
All right, so you're going to plead to impeding traffic, right? Responsible or not responsible to that? I'm sorry?
Responsible.
I'll accept the plea. Speeding's dismissed, 150. You're all set. Cash, you're into the hall. Best of luck. Maurice Sivan Simpkins, 25W839179. Could I have Kim Gilsbatch seated up at the table, my right, your left, please? Your name, sir?
Maurice Sivan Simpkins, sir.
Good morning to you. You're going to plead to impeding traffic, right?
Yes, sir.
Responsible or not responsible to that? Plea is accepted. Let me just double check something. Yeah, 150 is your total. Cash, you're into the hall.
Okay, got 2 weeks of paying my son.
Sure.
$2,200.
No problem. August 19th, you can pay by?
Yes, sir.
If you don't have the money somehow, call the court, go on Zoom. I'll give you an extension. Just don't ignore me. Honor before the due date, okay?
Yes, sir.
Best of luck.
All right, shoot, go down there.
You don't have to go anywhere. You can leave the building. Just August 19th, you have to pay by.
Thank you.
Good luck. Kim Marie Gilsbach, 25W839-148. Your name, ma'am? All right, so you're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible to that? Please accepted, 155, cash your end of the hall to your right, and you're all set. Original charge dismissed. Elise Ann Cosby, 24B147119. Could I have Luke Williams seated at the table over here? You can come up to the podium, Ms. Cosby, state your name.
Elisa Ann Cosby.
All right, you're charged with failure to refrain from having contact, direct or indirect, with Justin Cole and his immediate family. That is the charge. Plead guilty. If you're found guilty, this is a non-technical violation, a violation of the no contact provision. Your probation could be revoked and you could be incarcerated for a period of 90 days with your 771 status revoked and the conviction entered. You understand that?
Yes.
Did you sign the advice of rights?
Yes.
Did you read it?
Yes.
Did you understand it?
Yes.
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
You have the right to a lawyer. If you cannot afford one, either way, I'll appoint you one at public expense. Do you understand that?
Yes.
Would you like a lawyer?
I have one.
Who is it?
Steve, Max Dubin and Steve, but he couldn't be here today because his newborn baby's in intensive care.
Jeez, that's too bad. Why didn't you just call and get an adjournment? I would have given you adjournment. You drove all the way from Johannesburg?
No, I've been down here.
You hired Mr. Dubin to represent you on this?
Well, I spoke with him yesterday. I spoke with him a few days ago, and yes, we were supposed to meet to retain.
I didn't ask you that. Did you pay him retainer money?
Not yet, because of his emergency situation with his baby.
All right. I'm gonna enter a not guilty plea for you. We'll hire Mr. Dubin. I'll make a note, right? That's what you're going to do?
Yes.
I'll give you a new court date. and I'll give you a personal bond. You have to comply with all terms and conditions of probation, okay?
Yes.
All right, personal bond, $500. Comply with all terms and conditions of probation. We'll give you a new date, which will be on
August 14th at 9:30.
August the 14th at 9:30, okay? So I'm entering a not guilty plea for you. I want to be clear about that. You go down the hall, get your notice, and we'll see you here then. Any questions?
No, thank you.
All right, good luck. Kenneth Jerome Luke Williams Jr., 25F243686. Your name?
Kenneth Jerome Williams.
You're charged with failure to pay $305. If you plead guilty, if you're found guilty, you could be incarcerated, $309 actually. You could be incarcerated 1 day for every $10 owed. You could receive 31 days in jail. You can satisfy that in full by payment, in full by serving a jail term, or in part by payment, and in part by serving a jail term. You get $10 credit per day served. So if you paid $209, you'd owe $100, you'd only have to serve 10 days. You understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing. Do you understand that?
Yes.
You have the right to a lawyer. If you cannot afford one, you can apply for one at public expense. Actually, I'll just give you one. Do you want a lawyer?
Yes.
Where do you work?
Home City Ice.
I'm sorry?
Home City Ice.
Where is that, and what is that?
Ice.
Okay. How much do you make?
So we 24 hours.
Why didn't you pay this?
Because when I got pulled over, I have I was doing DoorDash at that point. So I had a amount on my phone, and the officer, it was raining that day.
You didn't show up. You didn't do anything. You lost. If you're gonna try to contest the ticket, you have to post a bond. You don't just not pay a ticket or not show up because you disagree. Is that what you're telling me? You disagree with what he wrote?
No, I called today. They told me that my court date was today.
The ticket was issued in April. You had 10 days to answer. Hang on. You had 10 days to answer. This is August. That's 4 months ago. You needed to call and request a hearing or pay the ticket within 10 days. You did neither. You went into default. So if you're saying you didn't pay the ticket because you didn't agree with the citation, that ship is sailed. You understand what I'm saying to you?
Oh, yeah. Oh, I didn't know that, sorry, but I didn't know I wasn't worried. The address that they had, I moved from, so they told me they sent me to work. They told me.
You got the ticket, right?
Yes, I had a ticket. I called and I set up a court date. And then.
You set up a court. Did he set up a court date, Lisa?
Yes.
Slow down. Slow down. I'm gonna see where he set up a court date.
Let me check, Judge.
They would have come in front of me. Did you leave a forwarding address?
Yeah, so the address.
Hang on, slow down. I'm just asking, did you leave a forwarding address?
No.
Do you live on, whatever 2377 is in Hamtramck?
Yes, that's where I live now.
We sent you this back in June.
Judge, it looks like a default card came back in return mail with a forwarding address.
I'll give you a choice. I'll give you a choice. You go down and post a bond if you want equivalent to the amount here. That's the rule. And you can make a motion to set aside default judgment, or I'll set you up on a payment plan. Whatever you want.
I do a payment plan. I pay whatever today.
You can pay whatever?
Yeah, I can pay a certain amount down.
How much do you have today? So you want to just take care of it that way?
Yeah. But I still get points on my, like I said, I got my money.
I can't do anything about the conviction at this point. Okay? But I will do this. If that's the route you want to go, I'll just have you pay $200 and I'll call it a day. I'll waive the balance. You want to do that?
Yes.
You understand the conviction's going to remain on your record, though. Balance waived, $200. Go down the hall, take care of that, and we'll call it a day, okay? Good luck. White, David White. David Michael White, 25W839022. Good morning.
Good morning.
Your name?
David White.
You look like a lawyer. Are you a lawyer?
No, I got interviewed after this.
All right, well, good luck with that.
I appreciate that.
All right, so what are we doing? You're pleading to impeding traffic, right?
Yes.
What happened here? Wait a minute. No, you didn't show.
It was originally scheduled for July 8th and.
Let me see something. Give me 1 minute here. Oh, I said motion to set aside default judge. I see. Did you meet with the department rep today?
I did before I came in here, yes.
You met with the department rep? I don't know why you didn't send anything in here. Who'd you meet with? Well, I don't have anything in here. So, did I miss something? Good morning. How are you?
Good morning.
Can you do me a favor and take this to Lieutenant Toller for me, please?
Of course.
I don't see any stip form in here on this case.
I can do that for you.
Thank you very much. Have a seat right at the table there. Cassidy Angeline Reardon, 25F244405. Oh, I'm sorry, officer. That needs to go in that file. My apologies. Ma'am, your name?
Cassidy.
All right, so you met with the department rep. You're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible to that charge?
Responsible.
All right, I'll accept the plea. 150, you're all set, okay? Original charge dismissed.
Thank you.
You all right?
Yeah.
You look scared. Good luck.
Thank you.
Martin, Ray Christopher Martin, 25F244339. Your name, sir? All right, so you met with the department rep and you're going to plead responsible, excuse me, to impeding traffic, true?
True.
To that charge, responsible or not responsible?
Responsible.
All right, you got insurance?
Yes, sir.
Okay, you got 3 of those on your record. You aware of that?
I was going through around financially, but I've been insured for about 2 years.
All right, I'll accept the plea, dismiss the original charge 155, okay?
Thank you.
Good luck. Crystal Martin? Crystal, I just didn't see a slip form in there.
That's okay. It just got turned around backwards.
Oh,
Sorry about that, Your Honor.
That's all right. Crystal Nicole Martin, 25F243723. Your name, ma'am?
Crystal Martin.
You're charged with a failure to pay. This is a show cause. Excuse me, for failure to pay $213. If I find you didn't pay and your failure to pay was not without your fault, you could be held in contempt and jailed. 1 day for every $10 owed. You get 22 days. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing. Do you understand that?
Yes.
All right. You want water? You have all the money?
Yes.
Why'd you wait so long?
Just busy. I work in the nights.
What's that?
I work in the nights, just busy.
Busy.
Yeah.
You gotta take care of your tickets, okay? You cost yourself more money.
Definitely.
I'll cut it down to 185, balance weight, okay? Down the hall and take care of that. Good luck.
Thank you.
Next time, call the court, deal with it, okay?
Thank you, yeah.
O'Neill, Tyler Aiden O'Neill, 25W839210. Your name?
Tyler O'Neill.
Gotta be careful, you caused an accident, right?
Yes, sir.
To the charge impeding traffic, responsible or not responsible?
Responsible.
Please accept the original charge dismissed 195. Cashier under the hall to your right. Good luck. People against David White, 25W839022. Your name?
David White.
You're going to plead to impeding. I have it now, okay? I don't know how I missed it, but at any rate, to the charge impeding traffic, responsible or not responsible?
Responsible.
How much of a bond did you post?
And the line fee.
How much bond did he post, Lisa? Can you tell me?
I believe it was 165, but let me look real quick.
Okay.
Yeah, 165.
All right, so I'll accept the plea. I'll set aside the default judgment. Fines and costs are 165. Just go down the hall and take care of that, okay? I don't know whose name it is. I don't see a bond receipt, so. Pardon?
He actually paid it instead of posting as a bond, so he's all set.
I see. So you're all set. You can leave.
Thank you.
Good luck.
Thank you.
Caitlin Marie Poor, 25W839149.
Good morning.
Good morning. Your name?
Caitlin Ford.
I can't take this. You got 4 moving violations, it looks like, in the last 5 years. So you can either plead to 30 and a 25, which is a 1-pointer, or you can set it for an informal hearing, whatever you want to do.
I'll take the point.
To the charge 30 and a 25, responsible or not responsible?
Responsible.
All right, I'm going to accept your plea. 135 is your total, okay?
Thank you.
Good luck. All right, Daniel Condon, Daniel Edward Condon, 25W8385531. Your name?
Daniel Condon.
Why'd you wait so long to come and talk to me?
What do you mean, sir?
Your ticket was issued in April.
No, I know, I set up a payment plan, Your Honor, and I just forgot about it. I received another ticket, and I paid it.
How much do you have today?
Sorry?
How much do you have today?
I can't pay anything today, Your Honor.
Where do you
That's
work
why I'm
at?
here. I need to request more time.
Where do you work at?
I work at Manheim Auto Auction. I was working through a time service making 19. They made me hire in for $5 less, so I'm making $5 less an hour.
When can you pay this?
If you could give me as much time as possible,
Do you get paid weekly or bi-weekly?
or weekly. But the next 2 weeks I have to pay my insurance and my car payment.
You pay $35 per week, beginning August 25th. Can you do that?
I'll make it happen.
If you don't have the money somehow, you call the court or come in here on or before the due date. Call the court, we'll go on Zoom, or you come in here on or before the due date. I'll be glad to work with you, okay?
You said August 25th?
Correct, that's a Monday.
Okay.
That's 2.5, almost 3 weeks, all right?
All right, thank you.
Good luck. Amy Nicole Zugaj. (214) 702-732. Is there a Emily Pardo here? Is anybody here that resides on Maidstone in Trenton on this case? Okay, your name?
Amy Nicole Zugaj.
It's, okay. Okay. Nobody's objected. So I'll just indicate, you staying out of trouble?
Yes, sir. I learned my lesson.
Good. There being no objection and you having been compliant, defendant granted early discharge from probation. You are all set.
Thank you so much.
Okay, we're gonna send you that paperwork and you should have it in the next few days, okay?
Thank you so much. I appreciate it.
Best of luck. Thanks. All right. Dean Allen Langle. 25T645958. Your name, sir?
Eli Joe.
Good morning to you. You're going to plead to impeding traffic, right?
Correct.
Responsible or not responsible to that?
Responsible.
Please accepted. 160 is your total. Cash your end of the hall. You're all set. Best of luck. Brad Allen Newick. How you doing?
Okay.
25T645787. Good morning. Your name?
Brad Gunner.
Okay, you're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible?
Responsible.
Please accepted. 195. You're all set. Original charge dismissed. Good luck. Cash your end of the hall to your right. Thanks. Barbito. Christopher Joseph Barbito, 25T646004. How you doing there?
How are you?
Your name?
Christopher Barbito.
All right. Got a coat on and everything, huh, Mr. Barbito?
Yes, sir.
Good for you. You're going to plead to, this is a commercial vehicle charge, huh? Why are you driving so fast?
There's really no reason for it, honestly.
All right, you're going to plead to impeding?
Yes, sir.
Responsible or not responsible to that?
Responsible.
All right, 185, cash your end of the hall to your right. Be careful, please. Slow down, all right?
I will.
Good luck. 2, Beisel. Joshua Daniel Beisel, 5B148957. Mr. Beisel, your name?
Joshua myself.
Okay, you're gonna plead to distracted driving, true?
Yes, sir.
To that charge, responsible or not responsible?
Responsible.
Please accept it, 155, you're all set.
Thank you, sir.
Have a good day. Kiera Nicole Duchesne. 25B148718. How you doing?
Good.
You all right?
Yeah.
Your name?
Curious.
Okay. You're gonna plead to impeding, right?
Yes.
To that, you gotta be careful, okay? Caused an accident, right? Yes? You caused an accident?
Kind of.
Well, tell me.
Oh,
Don't be shy. Nothing's gonna happen. Go ahead, tell me what happened.
it was a
Gotta keep your voice up, though.
it was a And then I like looked both ways, it was clear, and then I went, and then like I pulled out into the second exit.
Keep your voice up. I can hardly hear you.
Oh, sorry.
So you were turning on a red, right? Or not?
Yeah.
And so somebody else had the right of way, right?
What?
The other car had the right of way, right? When you turn on a red, they have the right of way, right?
Yeah.
And you pulled out in front of them, is that what caused the accident?
Like, they like ran a red light, and then.
They ran a red light?
I think so, well, I don't know, but I like turned, I'm sorry, like, I'm really nervous.
All right, listen, don't be nervous. Let's just do this. I'll just take the plea. We'll get you out of here, okay? All right, to the charge of impeding traffic, responsible or not responsible? Responsible? I didn't mean to upset you. There's nothing to be upset about. Everybody makes mistakes. Nobody was hurt, right? Right? You got the car fixed, right?
Yeah.
Okay. All right. Do you plead responsible to this impeding? Yes? You have to answer outright. All right. I'm sorry. I did not mean to upset you. Okay? All right. What grade are you in? Or are you done with high school?
11.
Okay. All right. I understand. You're a new driver, right? Okay. 195. You're all set. Relax. Take a deep breath. This is not the worst thing that's going to happen to you. Good luck. Brandt. Reese Timothy Allen Brandt. 25B148698. How you doing, Mr. Brandt?
Good, you?
Not too bad. You're going to plead as charged, is that right?
Yes, sir.
To that charge, responsible or not, or not responsible?
Responsible.
You gotta be careful, okay?
Yes, sir.
Caused a 3-car accident, looks like here.
Yes, sir.
195. You go down the hall and take care of that. Good luck. People against Van Tress, Felicia and Van Tress. 25B146084. How you doing?
Good, how are you?
Your name?
Felicia and Angela.
All right, so you're gonna plead to impeding, right? Responsible or not responsible to that?
Responsible.
Okay, I'm going to accept your plea. 170 is your total, okay?
Thank you.
Best of luck.
Have a good day.
You too, thank you. All right. Can I have Alexis Sophia Peterson? 25B148716. Good morning.
Good morning.
How you doing? Your name?
Alexis Peterson.
All right, so you are going to plead responsible to impeding, right?
Yes.
To that charge, responsible or not responsible?
Responsible.
Gotta be careful, okay? 195, original charge dismissed. Good luck.
Thank you.
You're welcome. Brian Bush. Brian Keith Bush, 25T6459708 and B. Your name, good morning, your name?
Brian Bush.
You're gonna plead to impeding traffic and no proof of insurance, true?
Yes, sir.
To that charge of impeding, responsible or not responsible?
Responsible.
To no proof of insurance, responsible or not responsible?
Responsible.
Do you have insurance
Yes,
now? Let me see it. Please accept it to impeding, that's 195. The no proof of insurance, that's in effect now, right?
Yes. I had the one that was in effect at the time, and then we refinanced our house, and we got a good deal on a bundle, so I just bought different insurance yesterday as well, so I have both.
You didn't have car insurance though on this offense date, right?
Not on me, no.
Okay. But you had it in
Yes.
effect? You have proof there that you had insurance on that date, which is July 12th?
Yes, sir.
Let me see it. John, can you just check that, make sure? So July 12th, and that was a, what kind of car?
Chevy Traverse.
Yeah, he was good through October 25.
All right, I'm gonna make it $50 on the insurance, okay? $195 on the impeding. Okay?
Is it okay if I have a little bit of time?
How much do you have today?
I can do 50 today.
You pay that now, the no insurance. How much time do you need to pay on
I
the
can have the whole thing by next Friday.
August the 15th, okay?
Yes, sir.
If you need more time, call the court. We'll go on Zoom. I'll give you an extension, or you can come in here on or before that date. I'll give you an extension. 8:30 in the morning, okay?
Yes, sir. Thank you.
Good luck. Gavin Lee Darnell, 25F2444395. Could I also have Brian Wada seated up here, my right, your left? Your name, sir? You're going to plead to impeding traffic, true?
Yes, sir.
Responsible or not responsible to that? Okay. $160 is your total. Cash your end of the hall to your right.
Thank you.
Good luck.
Thank you.
People against Brian Patrick Wada, 25F2444498. Good morning. Your name?
Good morning, Brian Wada.
You're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible to that?
Responsible.
All right, 165 is your total. Cash your end of the hall to your right. You're all set. Good luck.
Thank you.
Mohammed Naeem Khan,
Yes, sir.
25F244284. Your name, sir?
Mohammed Amin Khan.
You're going to plead to impeding? Responsible or not responsible to? All right, you're getting up there with these, though. You got to slow down. If you see my name on the next case, don't come in and ask for impeding. I won't give it to you, okay? 185.
Thank you, sir.
Good luck. Horn, Nicholas J. Horn, 25T704225FY. Your name? You're charged with failure to refrain from consuming alcohol, testing positive on a chemical, ETG, on a sober link rather, on July 18. That's count one. You understand the charge?
I do, Your Honor.
Count two, you failed to refrain from consuming alcohol, testing positive July 18 at 7:33 in the morning. You understand that charge?
Yes, Your Honor.
Count three, failed to refrain from consuming alcohol, testing positive July 18th at 7:49. You understand the charge?
Yes, Your Honor.
Those are three counts, but they still arise out of the same event, transaction, or occurrence. So I'm going to go ahead and just count it as one. So in other words, the most you could get is 5 days if you plead guilty to these. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights?
I did.
Did you read it and understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights. There will not be a hearing or a trial of any kind. You understand that?
I do, Your Honor.
You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
Yes, Your Honor.
I'll enter a not guilty plea for you. We're going to get you a lawyer. You're going to come back in front of me here today. The only problem is you do have 3 prior technical violations. So on a 4th, your probation could be revoked and you could be incarcerated for the maximum provided by law, which in this case is 1 year on the attempt R&O and 90 days on the disorderly. Do you understand that?
Yes, Your Honor.
You have any questions?
No, thank you.
I'm going to enter a not guilty plea. I'm going to give you a lawyer. You're going to come back in front of me with that lawyer. And then we'll have your hearing. Okay?
Yes, Your Honor.
All right, we'll see you back here in a few minutes. Thank you.
Instead of seeing the hallway.
And these are, again, the same charges. I just want to be clear. You have 2 counts. So both counts 1 and 2, you have these violations. And I'll see you back here. Thank you. Here you go. All right, Jody Lynn Kaminsky, 2, 5W832. Ms. Kaminsky, how are you?
I'm okay, I guess.
Your name? How'd you convince him to dismiss this?
I just told him the truth. I didn't know that you weren't supposed to record back on the highway. I really didn't.
Okay. Well, hey, maybe you should have gone to law school. You still could. Case dismissed, motion to the plaintiff.
Thank you.
Good luck, thanks. People against Shafiq, Muhammad F. Shafiq, 25T645-843. Good morning, sir. Your name?
Muhammad Shafiq.
You're going to plead to impeding, right?
Yes.
Responsible or not responsible to that?
Responsible.
I'll accept the plea, dismiss the speed, 160. Cash your end all to your right. Good luck.
Thank you.
Tariq Zarani, 25F244313. How you doing?
Good, how are you, Your Honor?
Not too bad. Your name?
Tariq Zarani.
All right. You're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible?
Responsible.
Please accepted, 150. Cash.
There is something I want to address, Judge. I didn't realize until I pulled into the parking lot today that I left my backpack that's got my wallet and my lunch. Is it possible to do it like tomorrow morning, first hour?
Yeah, you just admitted to not having a license on your person.
I don't know, I do have.
You're fine, you're fine, you're fine.
license that I
You're
can
fine,
do.
you're fine. No problem. I'll give you till the 7th. How's that? 150 is your total.
Sure. Thank
Okay.
you, Your Honor. Can it be paid early?
No,
So the
we're
7th,
gonna throw you away if you do. Yeah, of course I can.
7th or?
You can pay today, you can pay tomorrow, you can pay Thursday.
Okay. But like, what is the due date?
Thursday,
Thursday. Okay.
the 7th.
Okay. Thank you, Judge.
Okay?
Thank you. I appreciate it. Thank you.
Have a good day. Good luck.
Thank you.
Lindsay. People against Stephen Bruce Lindsay, 25F244281. Mr. Lindsay, how you doing today?
Good, how are you?
Your name?
Stephen Lindsay.
All right, so you're gonna plead to impeding, right?
Yes.
Responsible or not responsible?
Responsible.
Please accept the original charges dismissed, 150. Cashier end of the hall to your right. You're all set. Good luck.
Thank you, sir.
You're welcome. Amaya Danielle Saad, 25F244280. We getting backed up down there, Lisa?
No, she's doing good.
What's that?
No, she's doing good.
Okay. Your name?
Maya Saad.
You're gonna plead to impeding, right?
Yes.
Responsible or not responsible? Please accept the original charge dismissed, 165. Good luck. Can't wait to get out of here, can you? Have a good day. All right, Faizan Chowdhury. Faizan Zulfikar Chowdhury. 25B148998. Okay. Okay, so you're gonna have a hearing on this?
I guess so. I didn't know that was gonna happen.
You parked it next to a fire hydrant, it says.
I've been parking there for 25 years.
It doesn't matter, was the
No, it wasn't. I know my distance. I have it marked.
That's no problem. You want to have a hearing, I'll just,
When I-
hang on. I can't hear the case without him being here, so I'll set it for an informal if that's what you want me to do. That's what you want me to do?
That's what it is. It's
Okay.
efficient. It's just a principle thing. at this
That's
point,
all right.
You know?
That's okay. That's what,
Unfortunately, we're being harassed in that subdivision.
that's why we're here. You can have the hearing, no problem.
I knew if that was the first step I needed to do, I would have done that. I just didn't have that option. I had come in another, so it's like taking more time off of work or something. And I've talked to this officer, I know you can't hear it, but I understand. But this is very frustrating.
It says you parked in the fire lane next to
I'm
the
not in the
fire.
fire lane. And the fire lane's on the other side when I'm.
Okay, I'm not arguing. I'm not
I
arguing.
understand you can't listen to it, but I'm not in the fire lane.
I'm not arguing with you. I don't have a problem. We'll set.
I talked to the officer when he came back later and he.
Lisa, give me a date on this, okay?
August 14th at 9:30.
You're gonna come back next week, August 14th at 9:30, okay?
Can I get another date? I have an appointment at that date, August 14th.
What time's your appointment?
It's in the morning. I have a closing in the house.
What time's your closing?
It starts at 8 a.m. I'm not gonna be back here in this area by 9:30.
What time can you be back here?
Sure. Probably by the afternoon. I I'm going all the way to Farmington, and it's gonna take me a few hours.
Okay. Can we do the 15th, Lisa?
It's a Friday.
Can we do the 13th?
Yes.
August 13th at 9:30. So we'll
The
notify,
doctor's appointment for the children.
what's that?
I take the kids to go to the doctor's.
What time?
13th.
What time?
It's at 9:30,
Where's it at?
Dearborn. I can be back by 11 from that.
You want,
She's getting her braces off, so.
Lisa, can we do the 12th?
It's your civil day.
That's okay. We'll do August the 12th at 9:30, but send that over to Brownstown by email or whatever. August the 12th at 9:30, okay? So we'll see you in a week. You can go right down the hall, sir. Go right down the hall and they'll give you a paper notice, okay?
Okay.
Awais Chuhadri Akram. 25B148974. Your name?
Awais Akram.
You're gonna plead as charged to 5 over, right?
Yes.
That charge, responsible or not responsible?
Responsible.
Please accept it, 135, cashier into the hall. Good luck.
Thanks so much.
Forrest Michael Perez, 25B148508.
Where are you?
Good morning, your name?
Forrest Perez.
Okay, you're going to have a hearing on this, right?
Please.
You want to do the 14th on this one, Lisa, or?
Yes, 9:30.
So we'll do an informal hearing, that's what you want, right?
Yeah.
August the 14th at 9:30.
Fantastic.
Okay?
Thank you.
Good luck. Matthew James Joe Kazmarek, 25I414924. Your name? You're charged with failure to provide proof of completing 1 day of community service by June 20. You have no technical violations thus far. This is not even a probationary case, but I'll still adhere to that rule. You could get 5 days if you plead guilty, if you're found guilty. Do you understand that?
I do.
Did you sign an advice of rights?
Yes, I did.
Did you read it and understand it?
I did.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
I do.
You have the right to a lawyer. I'll give you one at public expense if you want one. Would you like one?
Yes.
All right, I'm gonna enter a not guilty plea. Go talk to a lawyer. Come back in front of me. It might take a while, but you come back in front of me.
Let's see.
He'll set you up with a lawyer out there. Holly Lynn Jacobs, 25F244424. And could I have Kyla Davis seated at the table, my right, your left over here, okay? Your name, ma'am?
Holly Jacobs.
All right, so you're gonna plead impeding, right?
Yeah.
Responsible or not responsible to that?
Responsible.
Please accept it, 150.
Thank you.
How you doing?
So now you.
Well, you're gonna come up here now, Kyla Madison Davis. 25F244425. How are you?
I'm good. How are you?
Good. Your name?
Pamela Davis.
You're gonna plead to impeding?
Yeah.
Responsible or not responsible to that? All right, I'm gonna accept your plea. What happened here? How old are you, 17, 18?
18.
Did you graduate? Next year.
No, I graduated.
Okay, good. What are you doing now?
I'm moving to Tennessee.
Really?
I'm gonna go to community college, become a stenographer.
To be a stenographer?
Stenography, like ultrasound.
Oh, I see. Well, great. Whereabouts in Tennessee?
It's like 20 minutes from Nashville.
Nice. Well, 165 is your total. I wish you well. I'll dismiss the original charge. Best of luck to you.
Thank you.
Here, have a good day, Mr. Ball.
Not too bad. How are you, Mr. McKay?
Good. Your name?
Jacqueline Ball.
Do you have anything today?
No, but I just paid a ticket yesterday, $252 in full. How much is it gonna be altogether?
This is the balance owed is 215 and 165. It looks like you owe 380.
Okay, can you drop it a little bit? I'll probably pay it today.
Yeah, I'll do that for you, Mr. Ball.
Okay.
Are you doing all right?
Well, not really. You got a job for me? I'll be all right. About $40 an hour. That's straight time.
$40 an hour? I'm not sure I make that.
I've been looking for 16 months, man. These guys just want to bring me in and have me fix their stuff for them and then, hey, fire me and shit. Or lay me out. They do me any good.
All right, here's what
I fix it for them. That's 3 pieces of equipment that they can get running or there's such a mechanic thing.
You have 215 you owe on one. I'll tell you what.
Who's that? Let me shut up. Sorry.
Make sure everybody's phones are off. Mr. Ball.
You owe 215 on one, Mr. Ball. I'll make that 170. I'll waive the balance, okay? I'll do that for you.
170 total?
Well, I can't do that. You owe 380.
Man, come on. Have a heart, Mr. Manette. Come on, you know me a little bit. For the last 30 years I've been here. Remember Superior Judge?
What's that?
I said you're the Superior Judge, remember?
What's the Superior Judge?
You told me that when I first met you.
I never.
Longest on the bench here.
I never said that.
I thought you said.
Well,
I know
no,
you've been here longer than Miss Hessen and that other guy over there is retired. I've seen you for 20-something years, you know? If I had money, I would have Mr. Ed Zelda came here with you, prosecuting attorney. But you know him, right? And his brother Dave, the judge.
Mr. Ball's been here longer than you almost.
I can tell you about how long you've been here. Almost. But anyway, all right, Mr. Minelli, so how much is that gonna be total for both of them?
You don't have any money, do you?
No, I don't, but I had 16 months I've been looking for a job. I got a couple of jobs and then they ended, you know, so. And I ain't getting no unemployment and I ain't getting nothing from food stamps or nothing either. They ain't giving me nothing.
I'll tell you what, okay, listen, I'm gonna do the best I can for you. If you need time to pay, I can do that. You pay 160 on the B file and on the other file, I'll reduce from 165 to 110. I'll do that for you.
Okay.
So your total's 270. Can you pay that?
Yeah, I'm gonna try and pay it by the end of today.
Balance waived, and you can pay by today?
Yeah.
Good enough, Mr. Ball. I'll do that for you.
Okay.
You're staying out of trouble, kind of, right?
Hey, I've been doing that. This is the only trouble I've been in, man.
All right, so you come back here with 270 and we'll be done. The balances are waived. I'm being too nice again.
Oh, come on. Yeah, you know, you don't want to be mean because I have to be mean too. But way to go there.
Have a good day. Good luck.
All right, you too, buddy.
Thanks.
Man.
Buddy, huh?
Yeah. Buddy, old pal, a friend of mine, man.
Take care.
All right, you too.
Peterson. Cameron David Peterson. Never a dull moment in this job. Never a dull moment. Cameron David Peterson here. 25T645907. Oh, he's not here. That's why he's not coming up here. Default judgment centered in favor of the plaintiff and against the defendant. Kozlowski, Jared Richard Kozlowski, 25F244430.
I know.
It is funny. How you doing, Mr. Kozlowski?
Good, how are you?
Not too bad. Your name?
Jared Richard Kozlowski.
You're gonna plead to impeding, right?
Yes.
Responsible or not responsible?
Responsible.
The original charge is dismissed. Please accept it 175, okay? Yes, you're into the hall. Do you right? Good luck. Thanks.
Thank you.
Mario Teron Hatch, 25B148848. Mr. Hatch, how you doing?
Oh, great.
Your name?
Mario Anderson.
You're gonna plead to impeding traffic?
Yes, ma'am.
You gotta be careful. You got a careless, reckless. Use your head now, okay? It's not good. To the charge impeding, responsible or not responsible?
Responsible.
Please accept it, 175. Cash, you're into the hall. Do you right? Good luck. People against Ahmad. Abdul Bassett Ahmad, 25B149081. Good morning. How you doing?
Good.
Your name? You're gonna plead as charged to this, right?
Yes.
Boy, you got people injured, transport, you gotta be careful to the charge of driving left of center causing an accident, responsible or not responsible. Please accepted, 195. Cashier into the hall to your right. Good luck. Umaz Ali Rana, 25, B148964. How you doing?
I'm good.
What's that say?
Sorry?
I'm just wondering what that says on your shirt.
It's like a brand name.
Okay, all right. I'm just trying to learn something today. You're gonna plead to impeding, right?
Yeah.
Responsible or not responsible?
Yes, responsible.
Pardon?
Responsible.
I'll accept the plea, 150, you're all set. Cashier into the hall. Good luck. People against. Kazmarek, Matthew James Choke, Kazmarek, 25I414924. Call in Emily, please. Good morning, Mr. Nahikian, your appearance.
One Nahikian, 1520 on behalf of Mr. Kazmarek, who is to my right, sticking to the record. Matthew Kazmarek.
So he's charged with one count, and it's there to provide proof of completing his 8 hours community service and providing proof by June 20th.
Correct. He did not provide proof. We would be pleading guilty to that today.
Is that what you want to do, sir?
Yes.
Even though you're not on probation, I'll adhere to that statutory language. The most you could get is 5 days. Do you understand that?
I do, Your Honor.
Did you sign the advice of rights and read and understand the rights?
I did, Your Honor.
If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
I understand.
To the charge, you failed to provide proof of completing 8 hours community service by June the 20th of 25. How do you plead?
Guilty, Your Honor.
Did you fail to provide proof of completing community service by that day?
Yes.
Anybody force you to plead guilty?
No, Your Honor.
You still wish to plead guilty?
Yes.
Please accept it. Has he done it?
Not yet, Your Honor. I went over all the places where he can do it. He knows of a few that he's gonna look into. We're just asking for a little time and if necessary, add 4 extra hours of community service to make it 12 and you'll get that done.
Why are you taking so long?
I've been trying to look for work. It has not been working out.
So you're not working and you still haven't done it?
No, I've been looking for work. I've been trying to get into places, trying to take the fine off too, which has been difficult without any income.
Your name?
Emily Casino.
How much do you owe? How much does he owe here? He owes $100, right?
He has been making payments.
I see that. He just missed, well, he hasn't, I don't know if he's missed. I don't think he has. All right, close enough. No excuse really to not have it done if you're not working. You served 6 more hours of community service. All community service hours to be done by, all community service hours to be completed by August the 28th. Do you understand that?
I do, Your Honor.
And that's only gonna be 14 hours, but you gotta get going, all right? I won't assess any costs. Do you need more time to pay?
I should be able to make the last couple payments here every Monday, so.
Okay, all right, if you need more time, call the court, we'll go on Zoom, I'll be glad to give you an extension. Just do it on or before any due date, okay?
Thank you, Your Honor.
Good luck, thanks, Mr. Nahikian. Nicholas J. Horn, 25T704225.
Good morning, Your Honor. William Gate 1520 on behalf of Mr. Horn, who is present to my left. Speaking director, Mr. Horn. Nicholas Horn.
Your name?
Emily Casino.
So he's got 3 prior technical violations. I arraigned him, I explained I'll only count these as 1 since they all really arise out of the same alcohol consumption given the time limits. But that would still put him where he could have his probation revoked and incarcerated for a year on the attempt R&O and 90 days on the disorderly. So you understand that, right, sir?
Yes, Your Honor.
What is he going to do, Mr. Neal?
Yes, Your Honor. I've gone over the violations. Mr. Horn will be pleading guilty. You gotta ask for the opportunity to allocate.
If you plead guilty here, you understand you could get 1 year on the 1 count, right? 90 days on the other, right? And you understand all your rights? If you plead guilty, you're giving up all those rights and there will be no hearing. Do you understand that?
Yes, Your Honor.
All right. As to the charge that you failed to refrain from consuming alcohol, I'm just gonna say on July the 18th, how do you plead?
Guilty, Your Honor.
Did you consume alcohol on July 18th?
Yes, Your Honor.
Did you test positive on the SoberLink blows at 7:16 on that date in the morning, 7:33 and 7:49 in the morning?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
I'll accept the plea to all 3 counts. I'm just gonna count it as 1 technical violation for the record. I'll just make a note, positive SoberLink blows, all 3 counts, but again, they rise out of the same event, transaction, or occurrence. So we'll count it as 1 technical violation, 4 total. Why does he keep doing this? Go ahead, tell me what's going on with him. He can't stop drinking.
So he did go a couple months without a violation. As you can see by his previous violations, they all kind of came at once. He was having a lot of issues. He got onto the SoberLink. He had been doing pretty good. This day was actually his brother's birthday. His brother had passed away, so it was a tough day for him. Not that his brother passed away on the 18th, but passed away previously, and this was his brother's birthday. So obviously, he didn't handle the stress and sadness that comes from that day appropriately, but he has been talking with his therapist. They have come up with a plan to address this and given him ideas on how he can address his bad days, how he can do it in a way that's not gonna impact him negatively, even aside from the probation. You don't wanna be drinking when you're sad. So he is addressing that. I think his therapist either sent Emily an email or is going to send Emily an email. He has completed his community service. I think he's made his payments. I'm just asking that Mr. Horn be continued on probation. If anything, maybe add some community service. But I do think he is improving, and that should be the goal of the probation.
All right. So I just want to be clear. He had a plea to, I don't know how many chances I can continue to give you, sir. You pled guilty to all counts consuming alcohol back in May. I ordered 1-day court work program and ordered also that you test weekly.
And SoberLink until September 1st.
Then you were in here in June, so you've been here the last 3 of the last 4 months of violations. What do you think?
It's hard to say. I did speak to Demaya at the guidance center. She's not recommending intensive outpatient because that was kind of my first thought. She said that she just feels like with his financial status, work schedule, and parenting life, that she doesn't think it would benefit him. This was on July 23rd. He was honest with her about the drinking event. He is attending his outpatient for the most part. It does look like
I want to clarify something. He's been on probation for basically 4 months and a week or so, right? He's had 3 drinking episodes. Why doesn't she think that this is important enough to require IOP?
I'm not a therapist.
I'm not either, but I don't understand that.
First thought, she said that.
Can I see the prior violations, please? Do you have those?
So you want to see them or you want me to read them?
Well, you can just tell me. I take pretty good notes, but I got chemical testing. This is on the show cause that's dated May 27th. I dismissed counts 3 and 4, and it was chemical testing. It looks like maybe misses on.
So it was for THC. It was essentially for new use.
April 7th and April 22nd, right?
Yep.
And then on the prior violation that he had.
It was April 24th. He had positive results on his sober.
why she doesn't think he needs IOP. Can I see the screening?
Yep. And I did just want to know, he did reschedule his individual appointments with Demaya. It looks like for June, he rescheduled June 4th and 25th, and then for July, he rescheduled July 2nd and July 16th.
Mr. Horn, I don't know if you're aware of this. You are, you got 2 prior drunk drivings. Now, I can't imagine somebody, I don't mean to criticize anybody, but I cannot imagine.
Well, and I'll be honest, I believe Mr. Horn has Medicaid, so it's not even necessarily Demaya. He has to meet certain criteria through like the Detroit Wayne Mental Health Authority. And I think it's like 3 drinking events in 30 days. Don't quote me on that, but it's something along those lines.
3 drinking events within 30 days?
Yeah, again, don't quote me on that. But it's something like that the county only, approves you if you have X amount of drinking events and so on. So I don't know if that.
He's coming off the sober link what day?
It was September 1st.
Anything else?
No, just, I guess, note that we all know insurance companies don't want to pay, so I think to lessen the chances of them having to pay for some sort of treatment is not surprising. I would just say that Mr. Horn, I do think he is improving, and I do think taking responsibility is a big part of that. I'm just asking that he be given one last chance to continue on this probation.
He hasn't been discharged from treatment, right?
No, he's in outpatient.
Panic to pay additional costs of $100. Remain on sober link until November 1. Serve 3 days jail. You have to complete treatment. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer. I hope that wakes you up, because you are a young man to have these criminal convictions and then keep violating. I'm sorry. Good luck. You're going to have a seat over there. I'll give him time to pay.
I'm sorry, do you want chemical testing and sober link to November 1st?
Yes, I'm sorry. I should have made that more clear. The chemical testing right now has been going, what, bi-weekly or weekly?
It should be weekly also.
And test weekly until November 1. This could have been worse. If you do it again, it's going to be, okay? I don't know what to tell you, sir. Good luck to you. Thank you. Thanks, Mr. Meekian. Oh, you can take all those. Sorry, I'm sorry.
Okay, thank you.
And then this. Michael Francis Harper, 25F244393. Morning, sir. Your name? You're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible to that?
Responsible, sir.
Okay, I'm gonna accept the plea. 165, cashier end of the hall to your right. Good luck.
Thank you.
Yeah, all the way down. Thank you. Whitfield, David Ray Whitfield the fourth, 25F244426. How you doing, Mr. Whitfield?
Doing okay.
Good. Your name?
David Ray Whitfield.
You're gonna plead to impeding, right?
Yes.
Responsible or not responsible to that? Okay, I'm going to accept the plea. 165, cashier end of the hall to your right. Good luck.
I have it there.
You too. Jamie Renee Moran, 25B148643. How you doing?
I'm good. How are you?
What are you, 16, 17? You backed up? You caused damage? Who's this, your sister?
Yeah.
I cannot get over how much you guys look alike. That's just ridiculous.
We get that a lot.
I'm sure you do. All right, you're gonna plead to impeding, right?
Yes.
All right. Okay. Minor damage to vehicle crash. All right, 195. Be careful, please.
Okay, also, Your Honor, is it possible to not have my probation rescinded?
You don't have probation. I'm not putting you on probation. You mean with the Secretary of State? I don't have anything to do with that. I don't have one thing to do with that. Okay? I'm sorry. Be careful. Good luck. Have a good day. Thank you. Rice. Nolita Rice. Nolita Wileen Rice. 25W838904. When did you show up?
I've been here.
Did you meet with the department rep?
I did.
Oh, you just want an informal, I see. Right? I see.
August 14th at 9:45.
No, there, you know impeding traffic has 0 points, right?
There were no signs on that road, and I'm not supposed to come around here, and I told that cop, I'm driving a Tesla, and the Tesla was malfunctioning, so.
They got you driving 41 in a school zone of 25.
I'm not from around here, I don't know the area, I told the officer.
You can't drive 41 in a subdivision, ma'am, in any
Gotta
city.
be some signage.
No.
There were no signs.
All right, well,
There's some signs.
No.
And my
No.
car registered my.
I don't care if you want a hearing, that's up to you, but, she was initially defaulted, why?
I'm on disability right now, I'm away from my job, and, sometimes, it causes confusion, and I have confusion with the dates, so my apologies there.
Okay, well, I'm not gonna set aside the default judgment, but I will set it for a motion, we're gonna set this for motion to set aside default judgment and informal hearing on that date, okay?
Okay, what date?
We're gonna give you that in one moment.
All right.
So we're setting motion to set aside default judgment, Lisa, and informal hearing. And we're gonna do it for August the 14th, and that's gonna be at what time?
9:45.
9:45. You can go down the hall, they'll give you a paper notice. Subdivision, you don't need signs. You can't drive 41 in a school zone. I'm just telling you. You do what you want, ma'am. You just do what you want. Good luck. Ashley Deshana Sullivan, 25F244-350. Okay. And this is going to be a plea. Your name, ma'am?
Ashley Sullivan?
You're gonna plead to impeding, right?
Yes.
You're gonna dismiss the disobey traffic control device to that charge, responsible or not responsible?
Responsible.
To impeding. I'll accept the plea. 165 says you need time to pay. How much time?
Yeah, it's just as much as possible.
Do you work?
I do work, I'm a single mother. I not really had a bad driving record ever.
Can you do $25 each week?
I have nothing today.
And I'm not saying
But
today.
I guess I can.
$25 due each week beginning on August the 29th. How's that?
Okay.
If you don't have the money, you call the court, we'll go on Zoom, or you come in here on or before the due date, 8:30. I'll be glad to give you an extension, all right?
Okay.
Good luck. John Joseph Goggin III, 25F244-202. Your name?
John Goggin III.
All right, you're gonna plead to impeding, right?
Yes,
To that charge, responsible or not responsible?
responsible.
Plea is accepted, default judgment is set aside, $200. You can go down the hall and take care of that. I realize you got your bond, just go down and deal with them down there, okay?
Down the hall to the right?
Yes, sir.
Okay,
Thank you. All right, Gonzalez, Jamie Elizabeth Gonzalez, 25W839106, defendant failed to appear at default judgment centered. Ashley Minta Cahosid Adams, 25W839076, default judgment. Kingsway Transport, 25W839024, A and B, default judgment. On both of these. And I'd save myself some time. Find out who the president is if you can, Lisa, or have somebody call Kingsway. Tell them if they don't pay these, we're gonna show cause the president, okay? Do I have anything else down there?
I have 2 more.
Hand them up, I'll take care of those. I'll get these people out of here. People against Wisniewski. Sandra Lou Wisniewski, 25F244363. Could I have Michael Smith seated at the table? My right, your left. Ma'am, come on up to the podium, state your name.
You sent me to the table?
Right there.
Right there, in front of you.
All right, to that charge of impeding, you're gonna plead to, right? Responsible or not responsible? 165 is your total, original charge dismissed, you're all set.
Just to let you know too, your husband, your father married my husband and myself 47 years ago
You're
in
kidding.
his courtroom. And we're still together.
That's great, 1978.
78.
One of my friends just sent me a ad of him when he was running for re-election in 1978. Crazy.
Yeah, we got pictures.
I can't believe it's 47 years now. I mean,
know.
where's time going? I was in college back in 78. He wasn't even in diapers yet. You.
I'm fine.
Take care.
Have a great day. Thanks for sharing that. Michael Ray Smith, 25F244361. Come on up to the podium, please. And tell me your name, sir.
Michael Ray Smith?
You're gonna plead to impeding, right?
Yes.
Responsible or not responsible?
Responsible.
Plea is accepted, 165. You can go down the hall and take care of that. Wish you well.
Is that any points?
No, it's 0 points.
All right, thank you.
Have a good day. Good luck. Where's his file? What's your name, sir?
My name is Sylvester. I don't know what that is. Never heard it. No. I don't know what is it.
Spell your last name.
Dieto Barton Sylvester. DDEDOS1EESTR.
Okay, slow down. Do we have anybody on the docket? Do you have your notice? Let me see your notice.
His last name was Bagman.
Bagna?
He's a 945 rep hearing with Flat Rock.
Okay, is Flat Rock still here?
Did you talk to an officer? Yeah.
Let's see if we can't get Flat Rock. I don't know where they are. I don't have a phone number. John, go talk to Flat Rock's department rep before he leaves, will you please? And set this man up. I think he's in courtroom number 2. I don't have a phone number.